Good evening, everyone. If you could find your seats, we're about to get started. Before we dive into our discussions today, let's take a quick moment to go over the ground rules for today's meeting. Number one, be punctual. Please join the meeting on time or a few minutes early to avoid disruptions and show respect for others. Number two, dress appropriately. Even though it's an online meeting, please dress appropriately to steer clear of appearing impolite and causing any discomfort of others. Three, minimize your distractions. Please find a quiet, well-lit space for the meeting and minimize background noise and distractions. Mute notifications on your device to avoid interruptions. Number four, participate actively. Engage in the discussion, contribute your ideas, and listen attentively to others. Please use nonverbal cues like nodding to show your engagement. And five, respect others' being time. Engage in the discussion, contribute your ideas, and make sure to avoid interrupting others while they are doing so. Please raise your hand to use the meeting chat if you would like to speak. Number six, use neutral language and tone. Please maintain a neutral demeanor in your language and tone to avoid using slang or inappropriate language. Number seven, be mindful of camera etiquette. Keep your camera on unless there's a valid reason to turn it off. Maintain your proper posture and avoid distracting movement or gestures. And number eight, please be patient and courteous. Be patient if there are technical difficulties or if someone is having trouble speaking. Treat all participants with respect and courtesy. Om Swastiastu. Assalamualaikum warahmatullahi wabarakatuh. Shalom. Nama Budaya. May peace be upon us. Good evening, everyone. I'm thrilled to welcome you all to our monthly discussion on global legal affairs. This event is brought to you by the Udayana Research Center for International Law and the Student Community for International Law from the Faculty of Law at Udayana University. I'm Audrey Ariella, and I'll be your MC today. We're here to discuss an issue of international law today, with the title, The Indonesia-China Joint Statement and the Future of Indonesia's Maritime Rights in the Exclusive Economic Zone. I'm excited to guide our discussion and make sure they're both interesting and informative. Thank you for being here, and let's dive in with energy and respect. The enforcement of international law has traditionally relied on injured states to take countermeasures. However, recent developments recognize the vital role of non-injured states in this process. This session explores the legal foundations, practical applications, and challenges of this evolving concept. We will examine case studies, legal justifications, and potential obstacles to provide a comprehensive understanding of how non-injured states can effectively uphold international law. Join us as we delve into the practical implications and future directions of this shift in international legal enforcement. Before we move on with today's event, I would like to call upon Dr. Imade Budi Arsika, as a LLM, as the head of the International Law Department at Udayana University's Faculty of Law, to give his opening speech. To Pak Budi, the time and place is yours.
Thank you very much. Hello, Audrey. Am I audible?
Yes, sir, you are.
Yeah. Thank you very much. So, first of all, I would like to express my gratitude to the facilitators of this great initiative, Professor Igusti Ngurah Parikesit Widiateja. So just confirm him that the today's session is the fourth session. So I'm so glad that we, the International Law Department of the Faculty of Law, Udayana University, could continue the programs that initiated by Professor Parikesit Widiateja. Thank you. And then also here I see there are several lecturers also, our great colleague, Bapak Made Martease, and also perhaps other colleagues have already joined, and also the presidents and the colleagues at the Student Committee for International Law, UNCIL, Audrey, and also here we have Miss Sarah Fergy Naomi Simanjuntak, Sarjana Hukum. We are proud of her. So just a few, let's say, so still this August, right? So it's still last week we celebrate her official graduations and now becoming the alumni of the Bachelor of Law students program, the Faculty of Law Udayana University. So, ladies and gentlemen, it is an honor again for the International Department of the Law Faculties Udayana University to, let's say, partly organize yeah, this event. The topic today is, this is very interesting. Yes, I think everybody still remember that the Indonesia-China joint statement raised both political and academic discussions with regard to the Indonesian exclusive economic zone. The main issues, as far as I observe, was whether the declarations adopted by both countries, so this is the soft law, academically classified as a soft law. So whether the declaration would ensure or not the Indonesia sovereign rights as stipulated by the 1982 United Nations Convention on the Law of the Sea. It is generally accepted, everybody knew that Indonesia is an archipelagic country. We are a great maritime state with having a long, great history about the sea. Therefore, Indonesia political interest in the South China Sea, we call also Laut Natuna Utara. Yeah. So the South China Sea are an integral part of our foreign policy. I'm expecting good discussions. So after hearing the presentations by Miss Sarah, hopefully there will be a response from the participants, and we expect the, let's say, the ongoing students, so the active students who interested in public international law, in particular the law of the sea, will get the will enrich their understanding about the current situation in the South China Sea. On behalf of the International Department, allow me to officially open this event. Thank you very much. Please, Audrey, proceeds to the next agenda. Thank you.
Thank you very much to Pak Budi for the wonderful remarks. And now, for the moment you've all been waiting for, all distinguished participants, I'm excited to introduce our speaker, Ms. Sarah Fergy Naomi Simanjuntak, a fresh Bachelor of Law graduate at Udayana University. Her thesis on today's topic is sure to both be enlightening and inspiring. Also, to help us navigate our discussions, please welcome our facilitator, Mr. I Gusti Ngurah Parikesit Widyateja, SHM Hum LLM and PhD, a lecturer at the Faculty of Law, Udayana University. His expertise will ensure we have a productive, further on, engaging conversation. Let us embark on this journey together, embracing diverse perspective and fostering constructive dialogue. To Mr. Parikesit, the time is yours.
Okay, thank you so much, Audrey. Good evening, everyone, all distinguished participants, distinguished organizing committee, and Sarah as a speaker, Bapak Budi Arsike, Bapak Mahartayasa, and also I also invite the new students from legal English class, from international undergraduate program class to join this session. And as information, these meetings, or this discussion group is created as a mean of facilitating students with special ability in English, after conducting final defense or final examination, then why not that she or he can present in English, so that the next or the future batch, or the next students can also learn how to present in the final defense or in the final project. So the idea actually was so simple, but hopefully it will give, especially for the new students of Faculty of Law Udayana University, to know the final defense or the examination is not that scary. It's not scary situation. Yeah, it is kind of like a sharing session. Why you interest to write this issue, why it is important, what is the legal issue, what is the implication, what is your solution, and etc. So from this session, hopefully all students will be more confident, will be more get used to about this situation. And now, in the fourth session, we talk about international law of the sea. We talk about UNCLOS, because one of I think comprehensive and strongest international convention is UNCLOS. To be frank, international law of the sea actually beyond my expertise, because usually I often talk about issue about international trade law, for example. But because we we are in international law department, have common agreement that if you have potential student to present, then you have to facilitate them, because Sarah Sarah is one of my student that I have supervised along with Bapak Mahartayasa, and Bapak Mahartayasa especially has a capacity in international law of the sea. Then I facilitate this discussion. Okay, before continuing to the presentation, let me briefly, because I understand not all know about Sarah, especially because now she is officially alumni of Faculty of Law Udayana University. So from her CV, I can read some important background about her academic journey. She is a detail-oriented and proactive law graduate with strong academic foundation. She was graduated with GPA 3.94 and hands-on experience in administration, coordination, and regulatory support. She has also work experience in public relations, especially as involved in I think, a kind of wedding organizer, and also had also experience as a customer loan factory in Bank Rakyat Indonesia. And for organizational experience, yeah, Sarah ever became a secretary of Asian Law Student Association, ALSA, from January 2024 until December 2024. She was a manager of Foreign Affairs Division in Asian Law Student Association. Yeah, that's the brief introduction about Sarah. And now we will see how Sarah will briefly reveal, because not many people aware about the issue of what's wrong with the joint statement between Indonesia and China. Yeah, that's okay. Our president and China president is like doing reciprocal. Yeah, Bapak Presiden Prabowo visit China and the president of China visit Indonesia. So what's wrong with the joint statement? For the lay people, they will think that that's a good sign of a cooperation. But please be mindful if in the international law especially, it's not just about economic or cultural issue. Yeah, there is also sovereignty issue, sovereign right issue. Yeah, how maintaining our integrity, maintaining our sovereignty is actually uh, Indonesia national interest. So if we didn't aware about the situation, especially Sarah will reveal, what's why we have to be worried when the phrase offer when overclaim issue become serious for Indonesia. And I don't want to go into detail. And before continue, I will also say thank you for Bapak Profesor Dr. Dewa Gede Palguna, SHM Hum, who already joined in this session tonight. Yeah, and thank you for all participants. The number is reached 70 participants now. So hopefully, after this discussion, we will be more aware about the issue of Indonesia sovereignty. So for Sarah, you have 20 until 25 minutes to deliver your materials. Time and place are yours.
Thank you, Prof. Parikasit. So, first of all, good evening, everyone. And I want to extend my respectful greetings to Prof. Parikasit and also Mr. Budi Arsika and also Mr. Mahartayasa and also Prof. Prof. Alguna that joined into this discussion tonight. So, okay. Okay, allow me to introduce myself. My name is Fergy Naomi Simanjuntak, and please allow me to present the result of my thesis entitled Legal Implications of the Indonesia People's Republic of China Joint Statement on Indonesia's Exclusive Economic Zone. So, next slide, please. So, waterways play an important role as shipping lanes because around 90% of global trade is carried out by the sea. The significant role of waterways in the international community can certainly lead to a conflict. Therefore, the United Nations has regulated the use of and marine resources through the United Nations Convention on the Law of the Sea, 1982. There are 157 countries that have ratified the UNCLOS 1982, which includes countries bordering the South China Sea, namely Indonesia, the People's Republic of China, Malaysia, Brunei Darussalam, Vietnam, Taiwan, and the Philippines. The South China Sea is a major shipping lane through which more than a third of the world's trade passes. A conflict arose in the South China Sea region, namely the PRC's claim to the Nine Dash Lines area based on historical traditional fishing ground claims. Settlement efforts have been made, including a settlement at the Permanent Court of Arbitration or PCA, which resulted in 2016 ruling to reject PRC's claim. However, the PRC refused to recognize and comply with the PCA awards. Indonesia has positioned itself as a non-claimant state in the South China Sea conflict since 1990. The historical claim is not in accordance with Article 51, Paragraph 1 of UNCLOS, which also violates Article 56, Paragraph 1 of UNCLOS. Article 56, Paragraph 1, which regulated the sovereign rights and jurisdiction of coastal states over the EEZ areas. On November 9, 2024, Indonesia and China made a joint statement between the People's Republic of China and the Republic of Indonesia on advancing the comprehensive strategic partnership and the China-Indonesia community with a shared future. Number 9 of the Indonesia PRC joint statement said that the two sides reached important common understanding on joint development in areas of overlapping claims and agreed to establish an intergovernmental joint steering committee to explore and advance relevant cooperation based on the principle of mutual respect, equality, mutual benefit, flexibility, pragmatism, and consensus building pursuant to their respective prevailing laws and regulations. So the substance of this joint statement has a meaning that is contrary to the basis of international law that has been recognized by Indonesia and the PRC because it contains the phrase overlapping claims. Next slide. So the problem formulation of this thesis. First, how is the legitimacy of the joint statement between Indonesia and PRC in the international law perspective? And the second one, what are the legal implications of the joint statement between Indonesia and the PRC on Indonesia's EEZ, particularly in relation to the South China Sea dispute? Next slide. So the theoretical foundations on this thesis. The first one is theory of state sovereignty. According to Jane Bodin, sovereignty is the absolute and supreme power that has an important role for a state in terms of regulating citizens and its territory, which is single, original, eternal, and anonymous. The second one is pacta sunt servanda principle, that in terms of implementing agreements between countries, the principle of pacta sunt servanda has an important role to ensure that both parties will carry out all agreed rights and obligations. The third one is binding theory of international law that say that the absence of a law-forming body doesn't mean that the law doesn't exist, but shows the effectiveness of the law. And the fourth one is relationship between international law and national law. International law and national law are legal arrangements that can be standalone or become an integral part of the same legal system. Next slide. This research is a normative legal research that uses case approach, statute approach, and historical approach. Source of legal materials in this research are normative legal materials, secondary legal materials, and tertiary legal materials that use library research and descriptive analysis technique. Next slide. So for the general overview, the first one is international treaty. The definition of an international agreement is contained in Article 2, Paragraph 1 of Vienna Convention 1969. In Indonesia, international treaties are regulated in Act Number 24 2000 about international treaties. Furthermore, the command law stores and manages international treaty texts in the treaty room. In the treaty room, joint statements are included in documents that are not legally binding but reflect political agreements or commitments. In the joint statement of Indonesia People's Republic of China on November 9, 2024, there are 7 main topics, which in this research focuses on the topic the two sides will jointly create more bright spots in maritime cooperation. And the second one is maritime zone boundaries. In international law, maritime zone boundaries are regulated in UNCLOS 1989. While in Indonesia, they are contained in Act number 6, 1969 about Indonesian waterways. According to UNCLOS, there are several types of maritime zone boundaries. This research focuses on EEZs, that the regulation of the EEZ in UNCLOS is contained in Chapter 5. While in national law, it is regulated in Act number 5, 1983 concerning the Indonesia EEZ. And the third one is South China Sea dispute, that in 1998, the PRC issued a law, the continental shelf, which included claims to the 9-dash lines based on traditional fishing grounds, that resulting in overlapping claims. In 2013, Philippines filed a claim with the PCA that on July 12, 2016, the PCA ruled that PRC had no basic law to make claims in the South China Sea region. However, the PRC rejected the decision on the grounds that the PCA had no authority over this dispute. Indonesia positions itself as a neutral party, that Indonesia not taking sides, which is caused by Indonesia's free and active foreign policy, or referred to as a non-claimant state. Next slide. The position of Indonesia PRC joint statement as an international treaty. The Vienna Convention on the Law of Treaties, in Article 2, Paragraph 1, letter and explains the definition of an international agreement, in which there are elements that must be fulfilled in an agreement, namely agreement, subject of international law, written form, specific object, and subject to international law. Judging from the language used, the joint statement of Indonesia PRC is general and aspirational, so that it does not create obligations for both parties. Besides that, it doesn't contain enforcement mechanisms or sanctions, and doesn't go through formal procedures such as ratification, but there are general goals to be achieved together. This joint statement is a political commitment which does not have legal force, but the joint statement still has moral and political burdens, namely, for the moral burden, there are international reputation, bilateral trust, and public and diplomatic pressure. And for the political burden, there are foreign policy commitments and also regional relations. Next slide. The legitimacy of the Indonesia PRC joint statement in the international law perspective. Controversy arises in number 9 of the Indonesia PRC joint statement because the two countries have a common understanding of joint development in the overlapping claim area, which is an area that causes disputes, namely the South China Sea dispute. This is not in accordance with Article 51, Paragraph 1 of UNCLOS, because the article explains that the traditional fishing ground is not a territorial area, but something that has been done for generations, so that coastal states must respect the area. And the second one is Article 56, Paragraph 1 of UNCLOS, that this article explains that the coastal states have sovereign rights and jurisdiction over the EEZ areas. And the third one is Article 58, Paragraph 3, UNCLOS, that this article explains the rights and the obligations of other countries in the EEZ area owned by the coastal state. Based on the international law, namely UNCLOS and the PCA decision, the PRC claim in the 9-dash lines area cannot be recognized in the perspective of international law. Next slide. Legal implications of the Indonesia PRC joint statement on Indonesia. The Indonesia PRC joint statement prioritizes the principles of mutual respect, equality, mutual benefit, flexibility, pragmatism, and consensus building. If we look back at the event that have occurred between Indonesia and PRC, vessels that often enter and carried out activities in the Indonesian EEZ illegally, the Indonesia PRC joint statement is expected to overcome these events. However, the praise of overlapping claims could threaten Indonesia's sovereign rights and jurisdiction in the North Natuna Sea, where the PRC could exploit resources in the North Natuna Sea area. If the Indonesia PRC joint statement signifies recognition of the PRC claims to the 9-dash lines by Indonesia, then this could disrupt security stability in the North Natuna Sea. Based on recognition of the Indonesia Ocean Justice Initiative, after the Indonesia PRC joint statement, the China Coast Guard ship entered the North Natuna Sea to disrupt Pertamina's oil and gas survey, which was then being guarded by the Marine Security Agency, or Bakamla, ship on November 11, 2024. Next slide. Legal implications of the Indonesia PRC joint statement on countries bordering the South China Sea. Hikmahanto Juwana, an international law expert at the University of Indonesia, explained that maritime cooperation can occur if the parties mutually recognize overlapping maritime zones. These are public opinions regarding the influence of the Indonesia PRC joint statement on the countries involved and affected by the South China Sea dispute. The first one is Karen Jean-Pierre, as press secretary of the White House from United States. She encouraged Indonesia to cooperate with legal experts to ensure that agreements made with the PRC are in accordance with international law, especially UNCLOS. The second one is Lin Jian. As the PRC Ministry of Foreign Affairs, she argued that the PRC pursues common development by putting aside disputes with Indonesia to actively explore other maritime opportunities and cooperation. And the third one is former Philippine Supreme Court Justice Antonio Carpio, who is a vocal critic of the PRC claims in the South China Sea. He argues that the Indonesia PRC joint statement is a big mistake by Indonesia, as it has no overlapping claims or disputes with the PRC, but refers to the Indonesia PRC joint statement as a joint development area. The PRC clearly has no claim to the area. The public is of the opinion that the Indonesia PRC joint statement shows that Indonesia implicitly recognized the PRC claim to the overlapping claims 9-dash lines. Indonesia recognition is not in line with Indonesia's position as a non-claimant state, which affects Indonesia public view and international reputation. Next slide. So for the conclusion, the first one, the Indonesia PRC joint statement is not an international treaty, but only a joint understanding that implies an understanding and agreement on the substance that is regulated in it. Although not legally binding, the Indonesia PRC joint statement has a moral and political burden. The claim made by the PRC is not based on UNCLOS and the PCA award on the South China Sea dispute, so the claim is not valid. And the second one, because of the praise overlapping claims in the Indonesia PRC joint statement, the PRC can make this joint statement the basis for Indonesia's recognition of the PRC claims, which can lead to new conflicts in the South China Sea dispute. The public considers that Indonesia is not in line with Indonesia's free and active politics and Indonesia's position as a non-claimant state on this dispute. Next slide. So the suggestions of this thesis. The first one, Indonesia needs to make a persistent objection to the PRC's claim in order to comply with UNCLOS and maintain Indonesia's sovereign rights in the North Natuna Sea. In addition, this can restore Indonesia's international reputation as Indonesia remains a non-claimant state. And the second one, Indonesia should strengthen its sovereignty enforcement in the North Natuna Sea region to deter illegal activities from the PRC. In addition, Indonesia is advised to coordinate with Asian countries, especially disputing countries, to find a bright spot in the South China Sea dispute so Indonesia could maintain its principle of free and active politics. That concludes the presentation of my research as outlined in my thesis. I apologize for any mistakes I may have made, and I would also like to express my sincere gratitude for your attention. Thank you. And that's all my presentation. Thank you.
Okay. Thank you so much, Sarah, that was a great presentation. I myself also run, although maybe since 3 months ago, yeah, I have read your thesis, but yeah, when it's turned to English presentation, yeah, some new knowledge, new understanding. I also read especially about why we have to be worried about the phrase overlapping claims. Yeah. So I just this is maybe additional information because the problem I just use term problem because overlapping claims is going to be a problem for Indonesia if we are not clarifying in the good way because in in the global perspective uh, if if the participant also follow China is now trying to be superpower country, trying to defeat another superpower country. China has like BRI. Here is bank, but BRI for China is Belt Route Initiative. And that's not only happen. That's not just cover Asian or Oceania, but also cover another region or even African. Yeah, you can check. Yeah, audience can check how the China strategy to be a global manpower. And the problem is not just with Indonesia actually. Yeah, Vietnam also have a problem with China. Philippines also have a problem. I think compared to those countries, Indonesia is more calm, more relaxed. It's not to react. You can compare with Philippines or Vietnam. They try to give harder protest, harder complaint with the movement initiated by China. But again, we know that Indonesia has strict territory. Indonesia has strict territory, and all the party of UNCLOS has recognized. But China later come, set the rule, set the standard unilaterally, and say that, because my great-great-grandpa, my great-great-grandma fishing on that area, we just want to continue. Because we used to do that in the past. So that can be, China assume that it can be our traditional activities, our traditional fishing ground. So because UNCLOS also to some extent regulate the issue, then it become a problem. And when you want to claim another state territory, it is what I should call, it is not fair if historical background becoming justification, and the historical background is not regulated under international law, particularly UNCLOS. Yeah, set the rule, set the standard, which is 9-9 line, and then make a statement with other country and put some word overlapping. What is overlapping? Because we have strict territory area. It's not like maybe if compared with the previous case like Sipadan Ligitan, yeah. Although that's different. This is about the sea. Sipadan Ligitan is about land, yeah. Yeah, the Sipadan Ligitan, the map, yeah. Indonesia has the map. Malaysia has the map, and the map is derived from the Indonesia. The map come from the Dutch. Malaysia come from the England, but all those map is not clear, and is not clear, and yeah, they have the same similarity, the same or strong position, the same strong position. So the judge then give award to the Malaysia because of effective occupation. Yeah, if you want to claim other land, yeah, the judge will see how effective, how serious, how well managed, how well administrative the country to if they are willing to occupy the land. Yeah, the situation a bit different, but in this situation, Indonesian territory is clear. Yeah, South China now, yeah, is definitely under the territory of Indonesia. So the China come and then make a statement and putting overlapping claims. That's actually the issue. Yeah. So yeah, this also become yeah, important for the future. Yeah, because we also have neighbor, not just with China. We have also neighborhood area with Australia, with East Timor, with Philippines, with Malaysia, with Papua New Guinea. Yeah. If they follow the way China is doing now, then it will endanger our territory. Yeah. So that's the a kind of brief overview. So before opening the session, so because I will ask for Bapak Profesor Dr. Dewo Gede Palguna, SIM Hum. You may ask or add some information because I know Prof. Palguna also interesting with the issue of law of the sea and time and place. Bapak Prof. Palguna, you may talk.
Okay, thank you, Professor Parikesit. And I would like to appreciate Sarah Simanjuntak for delivering your great presentation. It is, I think I would like to repeat my deep appreciation, especially to Professor Parikesit for initiating this program. And it is important to me for the student, especially for the student of Faculty of Law in general, and especially for those who take international law as their concentration in their final study. So I would like to also to thank Pak Budi Arsika for joining the program, and I would like to encourage any student, especially within the Department of International Law, to participate in this program. So this program will continue for the benefit of all of us, and even for the Faculty of Law of Udayana University and the Udayana University itself. So hopefully in the future we will have a much better, wider participants, not only students of international law department. All right. I would like to remind you all, especially you, the participants who interested in studying international law, that up to this very day, when we are talking about the sources of international law, we can only refer to the Article 38, especially paragraph 1 of the Statute of International Court of Justice, which is in Indonesia, it is called the formal sources of international law, while in the common law countries, it is called the material sources of international law. So when we take the joint statement into the scope or in the problem of sources of international law, so the question may arise is whether in the future China could base their argument to claim what is called as a kind of traditional fishing rights in the South China Sea to be a legal action. It could be a big question, because when we refer to the Article 38, paragraph 1 of the Statute of International Court of Justice, there is no such statement can be deemed as the former source of international law. But we know that customary law or the general custom, which is accepted as law, that is the main source, one of the main source of international law. So I would like to emphasize what Professor Parikesit just said. If maybe one day so many nations do the same act as what China do today, could it be deemed as a customary international law? Maybe that is the a rational question that may arise in the future. But at the same time, that is the interesting point of your thesis, Sarah. So I would like, I would not to ask you a question. I would not ask you a question in this evening, but I would like to again give you a kind of a deep appreciation for what you are doing with the thesis, especially under the supervision of Professor Parikesit and Pak Made Mahartayasa. Thank you. Great job. Yeah. Please continue, Prof. Parikesit.
Thank you so much, Prof. Palguna, for your additional but important points. Yeah. If many countries do that, then it can be assumed as international state practice. Then it's equal to international customary law. So it can be disadvantage for smaller countries, or particularly archipelagic country that have similar characteristic with Indonesia. So we need to anticipate not just for what has already happened, but also what will happen in the future. Okay. I will open now a discussion. So I will open three participant to deliver. You don't have to ask if you want to give appreciation or give additional information is also fine. And don't worry about the English because we are all learner. We put English as a second or even third or fourth language. So don't worry to make any silly mistake in this session because we are all learner. So who would like to be the first? Okay, Tiffany, Mane. Yes, times and place are yours. Tiffany. That's my student from legal English class. Tiffany, Helena, I will, and Putu Ayu Nabila. Okay, we have already 3 participants. Okay, Tiffany, you may ask now.
Okay, am I audible, Prof?
Yes, you are. Yes, you are.
Okay, well, thank you for the opportunity that given to me, but I'm sorry if my English is bad. Let me introduce myself first. My name is Tiffany Kinda Silvamani with student ID number 250455134. My question is, how can Indonesia balance its diplomatic needs with China as a strategic economy partner without sacrificing its maritime sovereignty in the North Natuna Sea? Thank you, sir.
Okay, that's short but excellent questions. Oh, how if how Sarah? How if I I ask student to raise the question and then you can answer all at once. After that.
Okay, Prof. It will work for me. Thank you.
Okay, balance and Helena. I'm sorry if I'm
Hello, am I audible,
Yes.
sir? Okay. Okay. So first, I would like to thank you, Sarah, for the presentation, and I would like to ask, the two countries, the both parties, PRC and Indonesia, why they decided to do a joint statement instead rather than creating a bilateral treaty, and what do you think? Do you have an opinion based on your research and findings when the two parties decided to do a joint statement based on the issue at hand? Thank you, sir. Thank you, sir, for the opportunity.
Okay. I will try to repeat just to make sure nothing left behind. But before that, let me invite Putu Ayu Nabila.
Good night, Prof. Parikesit.
Yes.
Thank you for the opportunity. Let me introduce myself. My full name is Putayan Baktavin Saputri. I will ask questions. What strategies should Indonesia adopt to ensure its maritime rights are not compromised in the long run? Thank you.
Okay. Thank you, Nabila. So, Sarah, you will have 3 questions. Tiffany asked about how Indonesia can balance economic perspective, economic cooperation without sacrificing Indonesia territory or maritime right, or more and less like that. Kemudian Helena asked about the why both country prefer to use joint statement instead of more powerful treaties like bilateral treaties, yeah, to facilitate their needs. And Putu Ayu Nabila asked about the strategy, future strategy, to preserve our maritime right. Okay, I think all is under your thesis actually. Okay, and please are yours, Sarah.
Okay, thank you, Prof. So the first one is question from Tiffany, that how can Indonesia balance Indonesia its diplomatic with China in economic without sacrificing EEZ, that in my thesis it's about North Natuna Sea. So that okay, wait for a minute. So the first one, Indonesia is have an free and active politics that we all know. And also in South China Sea dispute, Indonesia is a non-claimant state. So from your question, that how can Indonesia balance Indonesia its diplomatic with China in economic without sacrificing easy? Maybe you can check some treaties that Indonesia have with China. Indonesia have some treaties and some treaties and also partnership with China that in line in economy, but what that I discussed in my thesis, it's about Indonesia PRC joint statement that is not in line with UNCLOS because it have a phrase that said overlapping claims. So the main problem is all because the phrase that said overlapping claims, because Indonesia is an non-claimant state. So if Indonesia said a phrase that overlapping claims in the joint statement, it will ruin the Indonesia position of non-claimant state, and also it ruined Indonesia principle of free and active politics. Maybe it's my answer for the first questions from Tiffany. Is it good to you, Tiffany, my answer for your question?
Yes, thank you so much, Kak.
Okay, thank you. And the second one is from Helena, that why they decided to do joint statement instead of bilateral treaty. So I have discussed this kind of question with Bapak Martayasa. So Bapak Martayasa said that why Indonesia decided to have a joint statement instead of a treaty that legally binding, because maybe Indonesia want to check the reputation of Indonesia if they build a joint statement with China about 7 points that included in joint statement Indonesia PRC. And also joint statement, it's not a legally binding, but it has moral and political burdens that will causing Indonesia and also PRC maybe, because of if Indonesia and PRC have this joint statement into bilateral treaty, then Indonesia will have a bad reputation in the public, because Indonesia is an non-claimant state about from 1990. And also, Indonesia is not have a problem with South China Sea dispute, but Indonesia EEZ, that North Natuna Sea, is including into the area of 9 dash lines. That so why Indonesia including in the South China Sea dispute is because the area of South Natuna Sea is also including in the 9 dash lines, but Indonesia have no position in this dispute because Indonesia is a non-claimant state. So it all will affect Indonesia reputation, and also if it's legally, it cannot be legally because it doesn't align with UNCLOS, because the claim of PRC is based on traditional fishing grounds. That what I said before, it's not an territory that will give you some sovereign rights of the area. Maybe that's all my answer from Helena questions. But I guess Helena have asked the other question, but I don't get it. Maybe Helena can tell me one more time so I can answer the second question that she just asked before.
Okay, thank you, Sarah, for the answer. I'm really glad of your answer because it really reopening my knowledge about the law of the sea. For the second question, maybe based on your opinion and by research and findings, do you think there are any future? Is it good? Is it giving Indonesia a good or bad benefit from decided to this joint statement based by both parties, by China and Indonesia? Do you understand my question, Sarah?
Yeah, I understand, but I don't get it when you say that. Do you think and blah blah blah?
I'm sorry. Do you think Indonesia, from this joint statement, Indonesia will gain a good benefit or maybe a bad benefit instead, based on your research and your findings? Maybe your opinion is okay as well. That's the simple question.
Okay, thank you,
Okay.
Helena. So, for that question, I will say that from my thesis and from my research, Indonesia PRC joint statement have a good impact because some of the principle that they used is like what I said before. The principles of the joint statement used is have expected to overcome these events of illegally fishing or something else that PRC often do in Indonesia EEZ. But because of the praise overlapping claims, so this joint statement can affect into the bad way because although not legally binding, but Indonesia PRC joint statement has moral and political burden. And also the claim made by the PRC is not based on UNCLOS and the PCA award. So the claim is not valid at all. So if Indonesia said that in joint development Indonesia will bring bright future in this overlapping claims area, then slightly Indonesia have what did I say? Indonesia is agreed that PRC is have claim in 9 dash lines that it have a bad effect for Indonesia because it can affect Indonesia reputation itself. Maybe that's my answer. Okay.
Is it enough, Helena? Or you have
Yes,
follow-up?
thank you very much, Sarah and Bapak Dikasit. for the answer.
Thank you.
Okay, thank you, Helena. And
For the
the-
last one,
yeah, the last one is from Nabila. What's the strategy should Indonesia adopt to preserve Indonesia right?
Yeah.
Okay, wait. Okay, so from my thesis and also my research of this thesis that maybe Prof. Parikasit could help me answer this question if there is so maybe I will answer it as what strategy should Indonesia adopt to preserve Indonesia's right? As we know, and as what I said before, Indonesia is a non-claimant state, and Indonesia have no problem with South China Sea dispute. So Indonesia, as much suggests in my thesis, Indonesia should make a persistent objection to the PRC claims in order to comply with UNCLOS and maintain Indonesia's sovereign rights in the North Natuna Sea. In addition, this can restore Indonesia international reputation because this joint development is this joint statement have been deleted by Indonesia and also PRC. So Indonesia remains as a non-claimant state because when this joint statement when this joint statement making there are in my thesis there are eight public opinions that say that they don't agree with what Indonesia did in the of the joint statement because Indonesia is a non-claimant state, but Indonesia still make this joint statement with PRC that is slightly said that Indonesia agreed with PRC claims in the nine dash lines, and maybe it's my answer because in my suggestion of my thesis, I said that Indonesia have to make a persistent objection, and also Indonesia should strengthen its sovereignty enforcement in the North Natuna Sea. Maybe as an additional information that Indonesia, before it say Natuna Sea, before it calls EEZ of Natuna Sea, but in 2017 it changed. Indonesia changed that EEZ name. So North Natuna Sea because Indonesia want to strengthen its sovereignty enforcement in the North Natuna Sea region. Maybe it's my answer for Nabila question. Maybe Prof. Parikasit could addition my answer.
yeah, I think, thank you, Sarah. I think you already answer all the questions and mostly correct. Yeah, maybe what I'm trying to add is just additional information. Yeah, not to specifically answer a specific question, but I remember when we talk about, yeah, now we are talking about international law. But we know that international law is not law that what it is, it is. It's not like a national law when the structure, when the organ is so strict, divided with independent authority and etc. Sometimes the consideration is not only law, but also economic perspective. And I just remember, yeah, as Sarah also state that, yeah, This joint statement is issued after Indonesia has economic cooperation with China. Yeah. Indonesia has Asian, China, yeah, because Indonesia part of ASEAN. Indonesia has economic cooperation under Asian China FTA, yeah, free trade agreements. That's the reason why you will see many Chinese mining company, Chinese nickel company, Chinese electric car, and then some major infrastructure development are funded by not just Chinese government, but also Chinese state-owned company, Chinese private company. Yeah. So yeah, that's the reason why the government also, yeah, if the government strict, put law as the basis, yeah, that's yeah, that will also ruin the cooperation, the economic cooperation. And don't forget, in 2025, China and Indonesia are already united in the new coalition that's called BRICS. BRECS. Yeah, Indonesia joined on that newly aligned cooperation. Yeah, and yeah, from those situations, then yeah, we will understand that why it seemed like the government tried to accommodate. Yeah, maybe I'm wrong, but I'm assuming this joint statement. Maybe Sarah, have you ever checked the first draft? The first draft may be designed by the China. The first draft. That's why they can insert the phrase overlapping claims. And then after negotiation, then the government of Indonesia then okay, yeah, and government also understand, yeah, the joint statement is not legally binding. It is more likely like a soft law. Then okay, yeah, respect for what China has contributed for Indonesian economy. Then this joint statement finally agreed. Yeah, maybe that's the economic background why then joint statement is issued. For the strategy, yeah, that's a good question. Yeah, Sarah is correct when say that persistent objection can be can be used, yeah, at least to protect. But I think we need like more another statement maybe, just to make sure that, yeah, I don't know what is the reality. Yeah, okay, changing the name from the South China to the, yeah, changing the name of South China Sea into North Natuna Sea is a good strategy. The first strategy, but that's not enough because I just want to see how the Indonesian Navy will react if they find a sailor, a ship from China still in the North Natuna Sea. Yeah. What is the reaction of Indonesian Navy about that? Yeah. and this should be communicate well. Yeah, should we do Indonesia need to make a clear statement saying that, okay, we agree with this joint statement, but please respect and don't let your citizen, your ship to enter not Natuna Sea. Yeah, yeah. That's maybe the strategy in terms of law of the sea. Yeah, I don't know. Does this strategy already apply from the government? Yeah, because maybe this issue is sensitive issue. Yeah, sensitive issue, and not because the consideration of the diplomatic relation between Indonesia and China, then yeah, this issue maybe need to be clarified further. Yeah, because because we are worried if many ship, many uh, uh, sailor from China come to North Natuna Sea, but we can't do anything to protect that territory. Yeah, yeah. They need more statement to justify Indonesia policy to protect and to keep away every foreign unauthorized ship within North Natuna Sea. Yeah. We need a kind of statement to show our integrity and sovereignty. Yeah, I think that's just a brief perspective. And if you guys, audience, also have any additional information, yeah, then it's your time also to add. Or maybe if you still have any question, I will open also 3 more questions on this session. Okay, would you like to ask? Any more questions?
Pak Marikesit, so sorry to interrupt. First, Kak Sarah asked if it's okay to send her presentation in the chat box.
Yes, you are, Sarah. Yeah. That's presentation. That's not song. So you can share it.
Second, if it's okay, well, I know I am the master of ceremony. May I ask a question as well?
Yeah, definitely.
Okay. Thank you so much, Prof. And thank you so much, Kasara. My main question would more aim towards the point that you mentioned about reputation and implications regarding the joint statement. So, would it be that Indonesia, as a non claimant state, has a kind of political morality to not be involved in this joint statement, or is it actually a legal issue? Because, as we know in international law, legal binding power typically always has to correlate to the actual political standing of the country. Is that true? Yeah, and if you can explain a little bit about how that political ability correlates to the legal ability. Thank you.
Yes, you may answer right away.
Okay, thank you, Prof. So this so Indonesia is a non-claimant state, but Indonesia uh wait up. So Indonesia is a non-claimant state, but as if Indonesia is issuing a joint statement with PRC, and joint statement is an non-legally binding. So this joint statement it have not an legal effect for Indonesia and also for the PRC, but this joint statement is have a political morality because if you check treaty room from Kemenlu, this joint statement. So this joint statement is stores and manages international treaty text in the treaty room. That in the treaty room, joint statements are included in documents that are not legally binding but reflect political agreements or commitments. So you can check it in treaty room for the Kemenlu website. And also this political morality, it affects political morality, it affects Indonesia with some sort of effect that with foreign policy commitments that maybe if you read my thesis, I mentioned that Indonesia is one of ASEAN parties that Indonesia once have make make some commitment for this South China Sea dispute from ASEAN, but this joint statement is have it makes some other countries that asking why Indonesia agreed with this PRC claim, but Indonesia from the past Indonesia have known as a non-claimant state, and also for the regional relations it affect especially for ASEAN itself. Maybe that's all my answers, and maybe Prof. Parikesit have something else to say.
Yeah, I think I don't have any point. I think this will be clarified further, as I mentioned earlier. Yeah, because yeah, there is not just legal consideration in this matter involved, and not all information has made available in public, because yeah, I know that military and territory issue is not something that can be, yeah, some scholar say that is also under secret of country. So yeah, I need to do further research to answer this question. Yeah. How about you, Audrey? You have any?
Thank you so much. Yeah, that's okay for me.
Yeah. Okay, I think the time nearly over. I would like to say thank you for Sarah for everything that you have presented today. Yeah, well organized, well presented, and I think almost all audience will have a new insight about this issue. The issue, I think, although uh, it seemed like a difficult issue, but this is important because it is always important to maintain our sovereignty. We don't want to lose our territory anymore. Stop. No more East Timor. No more Sipadan Ligitan. We have to maintain. We have to seriously preserve our sovereignty. Not Natuna Sea is definitely our territory, and in the future, we have also to be aware with every possibility, other country try to enter illegally the territory of Indonesia. And thank you so much also for Pak Budi as a head of International Law Department, Bapak Profesor Dr.
Yes,
Dewa Palguna,
I'm very glad. Thank you.
Bapak Made Mahartayasa. Hopefully, Bapak Mahartayasa get fully recover. And also for all the participants, that join until the last breath of this session. Still 73 participants joining tonight. And have a wonderful weekend. Have a nice Saraswati celebration for those who celebrate Saraswati tomorrow. And may this session will continue with a better and wider audience in the future. Now, I return this session to the Audrey. Thank you.
Thank you so much. So, to Mr. Parkasit and Ms. Hara for an awesome discussion session today. We really appreciate your dedication to making this dialogue so meaningful. Furthermore, everyone, please make sure you fill out the attendance link we'll be sharing in the chat box. Once you complete the form, you'll get access to your certificate of appreciation. Finally, a personal thank you from me to everyone for their valuable contribution to today's discussion. Let's hope all of our insights we've gained, we can keep engaging with the topic of international law, specifically legal enforcement, especially by non-injured states. On the behalf of all the organizing team, we thank you for all your active participation. We look forward to seeing you at future events. Until next time, stay safe and stay connected. Om Santi 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 Om. Wassalamualaikum warahmatullahi wabarakatuh. Shalom Nama Budaya. May peace be upon us.
Thank you very much. Prof. Parikasit, thank you.